Hello, and welcome to the third of three audio recordings of articles I've authored on using letters of credit as a credit enhancement tool. I'm Ray Patella, and I'm an attorney of Kramer Burns, a full-service law firm located in northern New Jersey, primarily serving business clients in corporate matters, commercial transactions, real estate, litigation, and bankruptcy creditors' rights. We also assist individuals with estate planning and residential real estate needs. I practice in the areas of creditors' rights, insolvency, bankruptcy, distressed transactions, and litigation and other business law matters. Credit professionals often act as checks and balance against their sales department's potential risky attempts to bring in new accounts in their yearn for revenue. The credit department is responsible for evaluating the risk proposed by a new account and suggesting ways to either minimize that risk or enhance the creditworthiness of the new applicant. This last of three sessions focuses on how to stop a draw on an LC outside of a bankruptcy case. Courts and Uniform Commercial Code Section 5-109 permit the issuer of an LC to refuse to pay, notwithstanding the beneficiary's proper document presentation, if the document is forged or materially fraudulent, or if honor of the presentation would facilitate a material fraud by the beneficiary on the issuer or applicant. Note that the issuer has no obligation to dishonor the beneficiary's payment demand. The issuer may honor despite the fraud, as long as it does so in good faith. The UCC and courts fashion the fraud exception carefully. For example, the First Circuit Court of Appeals in a 1990 case held that a court may enjoin payment when it concerns fraud so serious as to make it obviously pointless and unjust to permit the beneficiary to obtain the money. Such circumstances would include where the circumstances plainly show that the underlying contract forbids the beneficiary to call a letter of credit, where they show that the contract deprives the beneficiary of even a colorable right to do so, where the contract and circumstances reveal that the beneficiary's demand or payment has absolutely no basis in fact, or where the beneficiary's conduct has so vitiated the entire transaction that the legitimate purposes of the independence of the issuer's obligation would no longer be served. Courts and legal commentators have long been divided as to whether fraud in a transaction should only include fraud in the LC transaction or should also include fraud in the underlying sales transaction. UCC Section 5-109 provides that fraud in the transaction includes both fraud in the LC transaction and fraud in the underlying transaction. Therefore, if the beneficiary committed fraud in the underlying transaction, the applicant may prevent the beneficiary's draw by requesting so to the issuer, although the issuer is under no obligation to accept that request. Also, the applicant may ask a court to enjoin the beneficiary's draw based upon the beneficiary's fraud in its underlying transaction with the applicant. A 2002 Ohio State Supreme Court decision held that the beneficiary's fraud in the underlying transaction justified an injunction against the issuer's honoring of the letter of credit, where foreign buyers promised American buyers they could sell certain goods, many of which the buyer applicants could not legally import or sell in the United States. The court issued an injunction because honoring the LC would facilitate the seller beneficiary's fraud in the underlying transaction, which was to sell the illegal goods. Many cases prompt courts to issue an injunction against payment or to justify the issuer's refusal to honor the beneficiary's payment demand for the beneficiary's fraud in the draw. For example, in one case, the beneficiary presented invoices and bills of lading describing the merchandise as bristles as the LC required. The beneficiary, however, had shipped cow hair and other worthless rubbish instead of bristles. The court held that the beneficiary was practicing fraud on the issuer by supplying the issuer with fraudulent documents instead of the fraud merely involving the beneficiary's breach of the underlying contract. The Second Circuit Court of Appeals, in a 1999 case, issued an injunction against the issuer bank for making payments to the beneficiary. The beneficiary could draw upon the standby LC only when the applicant failed to perform its obligations and only after the beneficiary submitted certain documents, including a default letter stating that the beneficiary did not receive payment due from the applicant. The beneficiary submitted a default letter to the issuer, and the Second Circuit affirmed an injunction against payment because the default letter was facially fraudulent. The default letter on its face was not true and could not have been true when the letter was written. In conclusion, we have discussed how to prevent a draw on a letter of credit outside of a bankruptcy case. Vendors and other parties in complicated commercial transactions are advised to seek the advice of counsel to minimize credit exposure in any given transaction by ensuring that the proper letter of credit is in place. In the interim, thank you for listening to this update, and please contact me at 973-912-8700 or via email at rpatella@kramerburns.com. I'm pleased to answer additional questions and discuss your specific situation.